Hello and welcome to this program of School of Law. Today I will talk about the new criminal laws which were passed in 2023 and which are coming into force on 1st of July. So many of you must be knowing that three laws which that is Indian Penal Code, Criminal Procedure Code and Indian Evidence Act. These laws have been replaced by three new legislations, that is Bharatiya Nyaya Sanhita for Indian Penal Code, Bharatiya Nagrik Suraksha Sanhita has replaced the Criminal Procedure Code, and Bharatiya Saksha Adhiniyam has replaced the Indian Evidence Act. These laws has tried to keep pace with the society, keep pace with the changes which has took place in the society in terms of social values or in terms of technological advancements. Today I will cover very few topics, 3 or 4 topics, because in half an hour it is not possible to cover the entire gamut of the changes which have been brought by these legislations. So I will today touch upon the community service, the first time offender, organized crime and proclaimed offenders. With regard to the community service, this has been introduced for the first time in our legal system. Earlier there was the punishment of fine, imprisonment, maybe a rigorous imprisonment, simple imprisonment, and various terms of fine, various periods for which the imprisonment can be awarded as punishment has been in our legal system. Now this new legislation in 2023 has introduced community service in the Bharatiya Nyaya Sanhita, and community service is one of the types of punishments which can be awarded to an accused. And community service is in a way a reformative kind of measure, and for petty offences, for non-serious kind of offences, the community service provisions have been provided, and the community service involves the completion of unpaid work within a given time frame as a form of reparative sanctions. It's a kind of punishment, and it correlates the nature of the services to the offense, and that means it should be in conformity with the, it should be in proportion with the offense committed, and it in a way fosters the sense of responsibility in the citizen, and enlightens the public about the it in a way lessens the burden on the prison system because less number of people are sent to prison. So this, in a way, because we are facing a situation where the prisons are overcrowded. Basically, for small types of offences, these provisions have been provided in our legal system, and it's a kind of a restorative justice system. And the community service under the Bharatiya Nyaya Sanghita, there are certain offences for which the Bharatiya Nyaya Sanghita has prescribed the provision of community service. For example, section 203 involvement of a public servants in a illegal trade, non-appearance in a response to a proclamation. Suppose a person has been issued a warrant and he does not appear, then in that case, an attempt to commit suicide to influence the legal authorities, first conviction of petty offense of theft involving the property of the value of 5,000 rupees. So for these kinds of offences, the community service, and community service can be in various places for social purposes. For example, in children, the person can be sent to do some service in children's homes, or some social service in villages, in elder people's home, the place where elder people resides, for places where persons with severe disability resides, or for construction of dams, etc. It has not, the list can be endless. There is no specific provisions which can be, we can say that, which can be, I mean, there is no specific kind of activities in which the person can be involved. The activities had not been exhaustively defined, but the purpose is that that it should be for the service of the mankind, for doing some kind of services in which the society gets benefit. Now we come to the provisions relating to first time offenders. Generally, it has been seen that due to some maybe some wrong understanding, or some immaturity of the understanding, or sometimes due to some kind of misleading behavior of other people, people commit offenses. So if the person is not an habitual offender, then it is believed, because we are living in a time where it is believed that the reformation is the best method of correcting a people, to make the people responsible for the society. So if a person had not committed a serious offense and there is a scope of his reformation, then in those cases the person, the first time offender, has been given some leniency in terms of punishment. So Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita both have incorporated this type of provision. So in Bharatiya Nyaya Sanhita, that is, which has replaced the Indian Penal Code, it introduces a kind of paradigm shift in terms of this with regard to treatment of the first time offenders, and it emphasizes the rehabilitation and compassion in the pursuit of justice. So in Bharatiya Nyaya Sanhita, it has reduced the first time offenders. In case of first time offenders, the punishment can be reduced in plea bargaining cases offenders, and it has liberalized the and relaxed the bail for the first time offenders. It acknowledges that the mistakes can be a learning opportunity for the first time offender. So for a first in Indian legal system, the first time the legal the framework under the Bharatiya Nyaya Sanhita aims to balance the accountability with an emphatic approach towards individuals with no prior criminal history. For instance, petty theft, which is made punishable with community service. So petty theft, as I mentioned in earlier also, for petty theft of value up to 5,000 rupees can be the person who has committed this kind of theft for the first time can be sent for community service, and it has introduced the non-custodial punishment such as community service and counseling for the for this type of offenders. It has the purpose of fostering the personal growth and societal reintegration through the legal framework. First time offenders are to be given relaxed punishments that is 1/4 and 1/6 of the minimum punishment prescribed for an offence. In plea bargaining, first time under trial offenders is given statutory bail after completion of 1/3 of the period of the maximum punishment provided for the offence. These are the some of the provisions. Section 111 of the Bharatiya Nyaya Sanghita, that is BNS, defines now we come to organized crime. Sorry. So organized crime is also one of the menace which has affected the society, and organized crime has been defined in Bharatiya Nyaya Sanghita, and the organized crime organic crime that targets a range of offences, including child abduction, robbery, cyber crimes, and other offences. Offences which were either not clearly defined or non-existent in the previous laws have now been introduced in a section section 112 of the 112 of the Bharatiya Nyaya Sanghita, and some petty kind of offences can also be treated as organized crime. So the activities, the organized crime violations are seriously dealt with by the new legislation, and it has also included the economic offences also, and the economic offences, that is criminal breach of trust, fraudulent transactions, schemes to defraud the banking services, to banking transactions, and it in a way deters the this kind of offences. So various kinds of offences in which a quite good number of people are involved are covered in the Bharatiya Nyaya Sanghita, and for these offences serious kinds of punishments have been provided. Earlier there was some state legislations which deal with, so for example, Makoka in Maharashtra, which deals with the organized crime, and in some other states also there was laws which deal with organized crime, but there was no kind of central legislation which deal with these kinds of offences. So for these kinds of offences, as we have mentioned, as I told you, that serious punishment has been provided. Now when another category of crime which I want to discuss today is the proclaimed offenders. And proclaimed offenders are those offenders who have been declared offender and who have absconding the legal system, who have run away and who have run away to avoid the legal process. So for these types of people, certain provisions have been made in the Indian Bharatiya Nagrik Suraksha Sanhita. The trial can be done in absentia, in their absence, and also the property can be attached, and if the notice has been sent, warrant has been issued, and for a considerable time the person does not appear, the trial can be conducted and his property, etc., can be sold, and its proceeds can be used for by the state, and also for the benefit of the victim. So these are the provisions which we have covered, and earlier in the CRPC, the proclaimed offenders could be dealt with in only 19 types of offences. But now any person absconding from legal proceedings in offences punishable with 10 years or more, or life imprisonment or death sentence may be declared as proclaimed offenders. And in Bharatiya Nyaya Suraksha Sanhita, for proclaimed offenders, a new provision has been incorporated, and this provisions provides for the identification and attachment and for attachment and forfeiture of the property of the such offenders, even the property situated outside India, if by mutual agreement with the foreign states, the Indian government can have access to that property. The property can be attached and sold. Bharatiya Nyayik Suraksha Sanhita also introduced the proceedings, the procedure for in absentia trial of proclaimed offenders. I mean, they can be tried in their offences. Now, the process will be the process will not be halted waiting for the proclaimed offenders. The proceedings can be started, and the person is deliberately avoiding the legal process. The entire proceedings can be conducted in his absence. So, in this way, we have covered some of the provisions of the new criminal laws. And this community service provision, which has been introduced, is a reformative measure. It gives a chance to an offender, a person who is not a serious offender, to realize his mistakes, and when he is involved with the society, he can learn many things in the society, and he can be sensitive to the needs of the society. Similarly, the first-time offenders, due to various reasons, various social, economic factors, the person may be involved in offenses. So these types of people should be given empathetic treatment, and that's why the provision has been made for community service and reduced punishment for these types of offenders. But at the same time, the organized criminals who are organized in now there can be many types of organized crime, economic offenses, cyber related offenses, kidnapping, abduction, human trafficking. So there are various types of activities where organized criminal gangs are involved, and for these people, the stringent punishment has been provided in our new legislation, and the law has, in a way, tried to define organized crime. And the proclaimed offenders, the people who abscond the legal process, who run away from the legal process, these people should not be should not take advantage of any kind of legal loophole. So the provision has been made to conduct the trial in their absence and to attach their property situated in India as well as outside India. So with this, we come to the end of our today's presentation. Thank you very much.